Welcome to Bcast, Benesch's business law videocast series. This is where we discuss the most topical legal and business issues. In this edition, we're going to be talking to Jackie Staple, an associate in Benesch's Labor and Employment Practice Group. Today, host Megan Mihalko is going to talk with Jackie about workplace sexual harassment after the Me Too movement.
Welcome. I'm Megan Mihalko, co-chair of the firm's Corporate and Securities Practice Group. I'm here today with Jackie Staple, an associate in our Labor and Employment Group. And today we're going to discuss workplace sexual harassment after the Me Too movement. Jackie, can I start with my first question?
Yes, Megan.
What is sexual harassment under state law?
Well, there are two types of sexual harassment, and the first type is the obvious one we always think of, and that's called quid pro quo sexual harassment, which just means a this for that. So it's a supervisor saying to a subordinate, have sex with me or you're fired. The second type is a little more subtle. It's a hostile work environment, and that's when hostile conditions are created because of a person's sex. So the workplace becomes offensive, humiliating, full of insults, to the point where the person's actual terms and conditions of employment have changed.
Does sexual harassment mean workplace conduct by a male towards a female?
Well, it could be, but not always. Sexual harassment can certainly involve a male to a male or a female to a female. What matters is that the behavior is sex-based.
Have you seen an increase in sexual harassment complaints against companies that you do work for?
Surprisingly, no. And actually, the Equal Employment Opportunity Commission, which hears charges of discrimination based on sex and sexual harassment, also has not seen the uptick that was anticipated in sexual harassment complaints. But what we have seen is companies taking more proactive measures now to update their policies and take other measures to prevent sexual harassment.
What can companies do to reduce instances and liability for sexual harassment complaints?
There are a few different things. So the first would be to revise policies. Be sure that there's a really thorough policy that is comprehensive and that involves not only defining what sexual harassment is, but also giving some examples, giving people a mechanism to report sexual harassment, and preferably a way to do it anonymously so that they can feel comfortable coming forward. And then to have a thorough investigation where all material witnesses are talked to. And then also a piece protecting people who come forward from retaliation, which seems to be very common with sexual harassment complaints. The other thing is to really train managers, not only in how to help people report sexual harassment, but also on their role working with human resources when there is a complaint, and also on how to spot certain signs of conduct that might lead to that hostile work environment. And then one interesting piece that some companies are considered is, what do you do when an executive is gone from the company but maybe has committed sexual harassment, which we've seen with the Me Too movement. You know, they've already been paid out, their ties to the company aren't really there anymore, or they're terminated, but under their agreements they get a big severance package. One idea that's out there is to put a clawback provision into agreements, so they actually have to pay back some of that money. So it gives them an incentive not to sexually harass.
Are you seeing those clawback policies being implemented in employment agreements today?
You know, we wish there were more cases of implementation. It's an idea that companies are considering, and we hope that continues.
Jackie, thank you very much for being with us today. Appreciate all of your insights.
Thank you, Megan.